Hello, everyone. Thank you for joining us today at RSI's quarterly compliance update. Today, we're going to take a look beyond the background check at your essential FCRA compliance playbook. Just a reminder, we are recording the webinar today, and the recording and slides will be sent via email within the next day or two. We want to start with our legal disclaimer. As you know, we are a consumer reporting agency and we are not attorneys. So any information given in today's webinar is educational in nature and should not be considered legal advice. Presenting today will be Brad, RSI's President and COO, Alicia, our Executive Director of Compliance and Operations, and Heather, one of our Client Relations Specialists. I'm Stephanie, and I'm the Director of Compliance and Project Management. Our compliance topics today include a review of why to use a consumer reporting agency, your key responsibilities as end users, common claims against CRAs and end users, working closely with clients and applicant data, understanding your scope for reporting, report reminders, disputes, and some common scenarios we come across when reporting records. We're also going to cover some Q&A with our FCRA attorney and adverse action. Throughout the presentation, if you have any questions at all, please submit them in the Q&A chat so we can answer them as we go. And I think Brad is going to get us started today.
Yep, thank you, Stephanie, and welcome everybody. Thanks for joining us. I might add too that we're doing these quarterly compliance, and you can go to our website and we are posting past content. So if you want to get caught up on some of the things we've done in the past, there's various blogs that are written there. So I hope that's helpful to you. And I think as we set up goals for today's call, I would kind of summarize it as, you know, there's a great relationship between ourselves as a consumer reporting agency and you, our client, and then also the applicant or your employee that is referred to as the consumer. And so today it's kind of helping wrap up that relationship between the three of us and how we can actually help for better reporting, also kind of reduce risk and possible legal risk protections for all of us involved. And then lastly, this entire process under the reporting of consumer report and background checks is really all for the protection of consumer rights. So we want to cover that too and kind of give you some foundation for some of the things and kind of the why do we do things and why we don't do things. So we hope this is helpful for you. So I'm going to start off with some of the basics, but you know, why are you using a consumer reporting agency like RSI? And so obviously at the top of that list is compliance. I think under the Fair Credit Reporting Act, you know, we do a good job, Alicia and her team and Stephanie there together, following all the relevant laws. Most of the laws that we follow are under the federal guidelines. We try to stay up to date on state issues, but really the state and local issues are up to you, our client, to kind of follow and keep us abreast of as well, because there's just thousands of them out there. And sometimes there's a local ordinance that maybe we're aware of or not, but we certainly have lots of resources to do that. Efficiency, you know, instead of you gathering data yourself, I can tell you at RSI, our National Criminal Database set is well over 2,200 different databases. So we have a process of pulling all that information together into a simple report so that you can make informed decisions based on relevant information that extends from you know, credit reports to the hiring and or renting, depending on the purpose of our reporting. And then we also do verification. As most of you know, we can look at verification of a candidate's information and help you make a hiring decision. And then lastly, you know, the consumer protection is a big deal. The Fair Credit Reporting Act ensures that we collect information and distribute it in a fair and accurate manner, and it provides the consumer the right to access and dispute the information. If you've never gone through a dispute, if anyone calls our office and they question that report, we create a formal dispute process, and that process to help that applicant correct information that may be wrong at the courts. I can share with you with the number of disputes that we've had this year, we've corrected about 45% of them. So the data that we pull is not always accurate, and that's part of the process. So key responsibilities of end user certification. So our clients are considered the end user. You're the ones that are using our reports. And so you certify through our terms and conditions that there's certain things that you're going to do to make sure that the process is is all put together and protects the consumer. So one is obtaining permission. So you need to get written consent. So we actually give you forms that you can do that in person in writing, but we also have the ability to do electronic consent. We provide the necessary consumer authorizations and disclosures. You have an obligation to give out summary of rights. You have an obligation to ensure accuracy. And I think it's a big part of this conversation today is what we want to talk about is how we can work together to ensure accuracy. Because once we complete a final report, consumer report that goes to your employee, it's critical that we kind of have all of our ducks in a row, if you will. So working with us to ensure accuracy is a big deal. And then the use of information is appropriate. So we have to make sure that you're protecting against any kind of discrimination, that you will not misuse the consumer report, that there's no third party viewing. And that's a big one. We do find that in some cases, if you have the need to share our report outside of your business unit and outside of that with your employee and a third party, let's say you have a contractual obligation with a construction company or someone's coming on site and you have to share one of our consumer reports, please call us and let's have that conversation, because there is some risk there that we need to try to avoid. And then you're using our reports for either employment or tenant purposes. And then lastly, your obligation is just to simply safeguard the consumer's rights, and that is to comply with all legal requirements, and then to do the adverse action process, which we'll talk a little bit more in this webinar. But I thought too that I would put out here, what are the common claims against CRAs and end users? And this is the top three. So non-compliant to FCRA disclosures. And we provide you the federal template, if you will, the federally approved templates for authorization and disclosure forms. We put big headers at the top to please consult with your local attorneys in case there's something there that you need to add. But I will tell you, trying not to add to those disclosures is a big deal. A lot of these courts are saying, hey, you've got way too much information in here that you're asking your consumer to sign off on, and it's confusing and they don't know what it is. So be extremely careful adding to our templates. We have our FCRA attorneys look at those every year to make sure that they're concise. We also ask you many times, we'll explain to you, hey, make sure these are on separate pages so that they're simple statements and separate pages so that things aren't confusing to the applicant. So secondly, following the adverse action process, failure to do so is number 2 on the claims. For those of you that don't know, adverse action is built in within our portal, but that process is a pre-adverse action letter. Then you wait 5 days on most cases, and then you can do a post-adverse action if we haven't called you to make other arrangements, because in that 5-day window is when your applicant can call us and dispute. And if we put it in dispute, then we tell you not to send the post and not to make a final hiring decision until we get back with you. And then lastly, conviction and arrest record discrimination. And so to sum this up, the failure to show a relationship between the conviction and the job function is highly abused. Kind of the basic example I often use is we send back a DUI on an MVR, but yet someone doesn't drive for the company and you use that DUI as a basis for not giving the job. So there's not a direct correlation. Since they don't drive for the company, then what difference does a DUI make on an MVR? So it's that kind of thing. So be very cautious in using our reports to make sure that there is a direct relationship to the job function for sure. And then these are some numbers that came out that I thought I would share. So under the Fair Credit Reporting Act, we are governed by the Consumer Financial Protection Bureau. And so the CFPB puts out these numbers on a monthly basis. And I wanted to just point out the fact that if you look across the board, you can see the FCRA complaints from September to October went up almost 25%. And then if you look to the far right on that FCRA line, you'll see that year to date, FCRA complaints are up 36%. And so I say this to our clients to say, these complaints are out there because consumers think something's wrong with the process. They're either complaining about us, the CRA, or they're complaining about you, the end user, or a combination of the two. And so be very mindful that these consumers are all about the process. So a couple of things, and these are just kind of best practices and some things that we see along the way. So we wanted to talk about this. So again, we're trying to put together a consumer report that is a summary of everything that we've been able to find out about your applicant that you've asked us to do. So most of those include a criminal report and some verification or even a drug test. But if you, as an example, know that there is a name change, say there's a middle initial, or there could be an alias name of some type that you're made aware of that doesn't show up in our documentation, make us aware of that, because then we can correct those reports, or we can look for those other alias names in that example. And this is a big one. If your applicant discloses to you that there's a past record, let us know that. Many times we can use that as an additional identifier, and we're going to talk about the process of having enough identifiers so that we have the confidence of putting records on a report. These county jurisdictions around the country, I will tell you, are redacting information, meaning they're removing date of birth, or they're removing address history, and they're removing all these things that we need as identifiers to have confidence that these records belong to the right person. So if you're aware of that, it certainly gives us one more identifier to make confident that we have the right person, especially in a common name scenario. If you collect documents that support a record, we need to know that. We probably need to put those documents within the portal on that applicant's summary page, so that if something comes up, say 6 months down the road, and there's a dispute to what we've done, those collected documents are a big deal with regard to a specific record that we've reported on. Making sure that you follow strict reporting procedures is really big. And we'll talk a little bit about this, but making sure that you have HR policies and procedures that match your decision-making process. And so, making sure that if there's certain levels of criminal record past that you won't accept, that should be documented within your reporting standards, and how we actually follow strict reporting standards, but you too can have strict guidelines within your decision-making process. And then making sure that any adverse action decisions are based, as I spoke a minute ago, on the job function requirement. And then having a quote unquote clean report and documents to support the report protects not only reference services, but you, our client. Whenever there's a lawsuit, we can all get drug into that because of who's being named in a suit because of something that was done, either if it's discriminatory at the client level, or if it's some report issue that we've placed out there. But all the things that we can collect together with our client will be the foundation of any legal challenges that we may see. And then, just so that you know this, once we get into a dispute, it's very difficult for RSI to have the ability to ask the applicant for additional documentation to prove their point. We can do it to a certain level, but our FCRA attorneys warn us about asking for further documentation that we didn't ask for in the process of creating the report. So it's almost like saying, if you need it now, why didn't you ask for it beforehand? So it can kind of put us in a tricky position. So that there again, this is why I'm saying to you, if there's things that you have and there's things that we have, we need to communicate about that before we finalize the report, so that we both have a level of confidence in what we're putting in the final report. And so let's see, I think with that, Alicia's going to talk a little bit about our standard scope of reporting and things that we can do to customize around that.
Hi, everybody. So yeah, we're going to briefly go over our criminal scopes and provide some clarity around the structure that we now have in place. As many of you know, federal reporting rules distinguish between two categories of criminal records. Convictions may be reported indefinitely, while non-convictions, including dismissed, pending, deferred charges, are only reportable for 7 years from the charge or file date. At the beginning of this year, we implemented a new standard 7-year reporting framework, and we made this decision for several important reasons. First, there are 9 states already that mandate some form of a 7-year reporting limitation, and several others are actively expunging older records with the Clean Slate Act. So as a result, many records beyond 7 years are incomplete, inaccurate, or inconsistent, which increases the risk of disputes and potential legal exposure. Second, our default county criminal search is driven by a 7-year address history. Because of this, applicants often assume we only review and report cases within that time frame. We get a lot of calls asking about that. Also, as Brad mentioned, employers' tolerance to types of risk is changing to be more in line with the EEOC. And therefore, most clients are okay with the 7-year reporting. Under our standard approach, we report both misdemeanor and felony convictions for 7 years. With one important exception, we will continue to include any violent felony convictions regardless of their age. This ensures that clients have visibility into the serious offenses that may impact safety. For our healthcare clients, we follow a different structure due to industry-specific regulations. In these cases, we report misdemeanor convictions for 10 years and all felony convictions indefinitely, or as far back as we can see them. Similarly, our clients in child-focused fields, including schools, foster care programs, and related services, fall under our maximum reporting scope. For these organizations, we report all misdemeanor and felony convictions with no time limitation. And we also may include non-convictions for 7 years. Most of those clients we do that for. And then although we offer these standardized reporting models, any client may request a customized report scope based on their policies or risk tolerance. However, even with customization, we also remain fully compliant with all federal and state reporting regulations. And then next, we'd like to touch on a few important reminders regarding how reports should be viewed and interpreted. As part of the end user certification that Brad mentioned earlier, every client agrees to review the entire report when making a hiring decision. It's important not to rely solely on the summary section on the first page. The summary is simply an overview. It does not define the level of severity of the alert, and a full review ensures an informed client hiring decision. I also wanted to emphasize the Social Security trace cannot be used to make a hiring decision. Its main purpose is to help us identify address history so we know which counties to search for in the criminal portion of the background check. It's not a verification tool and should never influence eligibility. And then finally, each client should maintain a written hiring policy that clearly outlines which types of records may disqualify a candidate. Having this documented policy protects both you all and the applicant, ensuring decisions are consistent, fair, and legally defensible. I believe now Stephanie is going to take over.
Yeah, thanks, Alicia. And right now we're going to look a little bit at our low dispute rate. So RSI has maintained a low dispute rate in 2026 of 0.06%. There are several factors that we use to help us maintain this level of accuracy year after year. At RSI, we adhere to strict reporting standards to ensure integrity and reliability in every record we handle. This means that we must follow all FCRA, federal, and state restrictions without exception. Every record we report must be supported by at least 2 personal identifiers, and for common names, we require 3 identifiers to avoid errors. And the identifiers include the full name And just note, it's always the best practice to include the middle name or middle initial on the order. Address, social security number, driver's license number, date of birth, and any applicant disclosed information. Like Brad mentioned before, this is where you as an end user can help RSI. If your applicant has disclosed a record, if you make us aware of that record, we can use that as an identifier, and it may make the difference between a previously unreportable record being allowed to be provided on a consumer report. Next, I'm going to talk a little bit about name grades. So above or previously, I mentioned that common names require 3. So how do we know what's a common name? Name grades uses a proprietary algorithm to source through decades of registered names to weigh how common any given name is. So this allows RSI to establish a standardized policy to treat common names with a greater standard of care and ensure maximum possible accuracy. So we operate under a conservative 60% threshold to maintain quality. Additionally, we offer biometric ID verification as an extra layer of security. Using advanced identity verification techniques, including multi-factor biometrics, allows us to verify the applicant is who they say they are, reducing the risk of fraud. Verifying an applicant's identity before conducting a background check streamlines the screening process, reducing the risk of false positives or false negatives, and provides additional assurance that the information that you receive as our client is trustworthy. When it comes to disputes, RSI follows a strict dispute handling process. We document every step and keep both the applicant and client, you as our client, informed on the status. All of these factors are critical because plaintiffs' lawyers are actively looking for mistakes, and even small errors can lead to significant consequences. Just overall, accuracy, compliance, and attention to detail are not just best practices in this area. They're essential to protecting both our clients and RSI as an organization.
Stephanie, I might add, it's it's interesting to know that when someone calls our office, they don't have to use the term dispute. They can simply ask a question about, hey, that's not my record, or they can say anything that questions the report, and that flags us to put it into a formal dispute process. And to put that into real numbers, we've only had like 60 disputes this entire year. It's amazing with the hundreds of thousands of background checks we do to only have 60 disputes. So just to tell you that we're really conservative in our approach just because of that. But working with our clients really makes a big difference when we can kind of help each other, make sure we got the proper information on a consumer report.
Yeah, and now we're going to take a look at a few scenarios that come up when we are discussing the reporting of criminal records. So starting with scenario 1, why can't a CRA report from public access to criminal records, which is the federal PACER records? First is accuracy. The FCRA requires CRAs to maintain reasonable procedures to ensure maximum possible accuracy. Public record searches, especially automated ones, can easily lead to errors. Information in PACER might be outdated, linked to someone with a similar name, or show charges without their final disposition. An example of this would be a CRA reported a felony charge from PACER that was later dismissed, but the dismissal wasn't updated in the public record, and the consumer lost a job opportunity and filed a lawsuit resulting in a 6-figure settlement for FCRA violations. The second is permissible purpose. Under the FCRA, a CRA must have a valid permissible purpose to provide a consumer report. If our matching procedures are insufficient, such as matching by name only, we risk reporting on the wrong person, and that is a serious violation of the permissible purpose rule. An example of this is CRA matched a criminal record to an applicant based solely on first and last name, and the record actually belonged to someone else with the same name living in another state. And that CRA was cited for failing to ensure proper identity matching. And remember, the Consumer Financial Protection Bureau has made it clear that disclaimers do not fix these violations. You cannot just say on your report, this is a name matching only, and it will, exempt you from the requirements. Overall, using PACER for criminal record reporting is not allowed because it can lead to inaccurate information and impermissible reporting. And there are real consequences like lawsuits, fines, etc. So we work to protect consumers and fully comply with the law. And now Alicia is going to look at some other scenarios with you.
So then the next scenario, in this situation, a client independently ordered a patch report, which stands for the Pennsylvania Access to Criminal History. It's sort of like a statewide. Patch reports display all information on file, including convictions, arrests, dismissed charges, even if some of that information may not be legally permissible to use in the hiring process. Because patch reports include details that extend beyond the 7-year reporting scope and beyond what the FCRA allows, it often shows more than we're legally permitted to report. So in this instance, the client then contacted us to ask why a particular record appearing on the patch was not included in our report. So once we've researched this, we found that we did identify and see the record on the nationwide criminal database. And as required, we ordered the county level search to verify it before determining whether it would be reported. When the record came back on the county level, it included only a first and last name. There was no date of birth, SSN, address history, or other identifiers to help us confirm the match. So we then ran the name grades that Stephanie mentioned, and it produced a 70% match score, which is too high to provide reasonable confidence that the record belonged to the applicant. So after exhausting all available avenues to locate additional identifiers, we could not confirm the record, so we did not report it. Because of this, and in compliance with the FCRA, that record was not able to be reported. So this scenario is a good reminder that while outside sources like the patch report may display broad information, we're legally obligated to verify identity and accuracy before reporting anything. And we must follow the federal and state compliance standards, regardless of what another report may show. And then the next scenario, a client contacted us after learning that one of their employees had been arrested in the past. They had conducted their own research and found a news article indicating that the individual had been arrested several years ago for a serious crime. Naturally, they contacted us wondering why this information did not appear on their report. So after investigating, we discovered that our nationwide criminal search never received any notification of this case, and the subsequent county level search also returned no record. We then reached out directly to the courthouse, where we learned that while the individual had indeed been arrested, no formal charges were ever filed, and therefore there was no case to report. So these examples kind of highlight situations that may initially appear as missed records, but upon further research, there are logical and verifiable reasons for why certain information does not appear on a report. But we always appreciate when clients reach out with questions, because it provides us an opportunity for us to explain the process, clarify clients' requirements, and in some cases, we learn from the situation ourselves. So open communication ensures that everyone understands the limitations and protections inherent to the reporting process. And I think Brad is taking it over again.
Yeah, thanks, Alicia. And then just lastly, I just want to give you all some confidence that we do work with what we think is the best FCRA firm in the country. And so we're constantly in communication with our FCRA attorney over different reporting standards, interpretations of the law, which is a big deal. You know, a lot of these statutes are written and you can interpret them different ways. So having an FCRA attorney kind of points in the right direction. So I'll give you a couple examples. You know, Kentucky has a reporting law. The Consumer Reporting Agency has strict restrictions about no consumer reporting agency shall maintain or should maintain information in its files relating to charges of a criminal case unless the charges resulted in a conviction. So we actually had a couple of scenarios where we sent that off to the attorney, asked a couple of questions, and the issue was, look, just only report convictions. There should never be any pendings, any dismissed, or items of deferred adjudication for the state of Kentucky. in this particular question is, should we report why an individual is on an exclusions list, like a medical exclusions list or a sex offender registry list? And the answer here is we should not report why they're on the list unless it's under 7 years. Best case scenario is just to flag that they're on the list. And then what we do is we provide a link to the actual exclusion data so that you can read for yourself what the reason for being on the list, because those reasons vary. And usually the reason are not something that we would ever report on the consumer report itself. Again, under the guidance of our FCRA attorney. And then it's the same thing. We talked about this a little bit earlier. Can we put address history, our social security trace information on the consumer report? We use both of those for credit. We use what we call header data, which gives us the social security trace, as we talked earlier, gives us address history, but neither one of those can actually be used for making a hiring decision. So they're not FCRA compliant, and therefore we don't put the information on the report. We do see it on our admin side, so it helps us go to the actual county that we should actually be searching for based on that address history, but nothing within the report can be shown. So I hope that helps kind of give you a little bit of a foundation for some of the things that we do on the back end to make sure we're reporting correctly. And then I'll just flip it back over to Steph and we'll finish up here real quickly.
Yeah, thanks for hanging with us, everyone. We realize we're a little bit over time, but we just have a couple more slides to get through. So now we're going to look at adverse action. Adverse action notices are not optional. They're required by law. And these notices inform an individual that they have been denied credit, employment, insurance, or other benefits based on information contained in the consumer report. At RSI, our templates are designed to follow federal requirements and ensure compliance with the FCRA. And this includes 3 steps: pre-adverse action notice, which is the initial notification that gives them the opportunity to review and dispute the information; the 5-day waiting period, so you need to wait at least 5 days; and then the post-adverse notice, which confirms that the decision is final once the waiting period is over. But compliance doesn't stop at the federal level. You also need to check state regulations, especially in states like Illinois, California, and New York, which have additional requirements. It's important to note that RSI does not adjudicate on behalf of our clients, and the decision-making process on hires remains with the client. However, at a client's request, RSI can add additional jurisdictional reminders in our adverse action process when special state assessments are required. So some examples of that are in Los Angeles, New York, and Illinois. And now we're going to look and see, Heather, I don't know, have there been any questions coming in throughout the presentation?
I have not seen any yet. Oh, one just popped in. Based on a phone call I had a few days ago, you all recommend waiting 5 business days. That is correct, Eric. The FCRA doesn't state exactly how long. They just say a reasonable amount of time. And it's just an understanding in our industry that 5 business days is a reasonable amount of time.
All right. I guess
And I
that covers.
See any other questions?
Okay. All right. Thank you, Heather. And thanks for that question. If there are any other questions, please feel free to throw them in the chat as we're doing these key takeaways, and we'll get them addressed before we wrap up. So just some key takeaways for today. You can collaborate with RSI to reduce risk and ensure accurate consumer reports. You also want to be sure to align hiring decisions with your HR policy. Confirm if the alerted activity relates to the job responsibilities, and be sure to review the entire consumer report. And remember, FCRA complaints are up 36.4% year to date. A couple of points about RSI. We adhere to a strict I switched those around. We adhere to a 7-year reporting scope with customization options, and we do follow strict reporting policies using 2 to 3 identifiers depending on the commonality of the name. Please remember that not all records are reportable and most require county court verification, and you can always consult directly with us if you have any questions at all. Just as a reminder, please be sure to check the RSI news and announcements on the client portal often for important updates, including upcoming webinars, counting delays, and compliance news. And as always, you may contact help@referenceservices.com with any questions you may have.
No
I
more
don't think-
questions.
Okay, thank you, Heather. A copy of the slides and recording will be emailed out to all who registered for the webinar within a few days, and we'd like to thank everyone for attending today.